Whether you own a property in Texas or you're renting one, it's wise to get familiar with what the law says about your rights and responsibilities. This is how you avoid getting into complicated, messy, time-consuming, and expensive legal predicaments. In this video, we'll briefly review what Texas rental laws say about the types of lease agreements used in Texas, what disclosures a landlord is required to make about a property, how to conduct a legal eviction in Texas, and more. Don't forget to hit that subscribe button so you can access more videos like this one, which break down complicated legal matters you'll encounter throughout your life. First, let's talk about lease agreements. These are contracts that lock a landlord and a renter into a rental arrangement. They are designed to protect both parties. The first type in Texas is a standard lease agreement. A standard lease agreement covers a fixed term, typically 1 year, so it has a start date and an end date. The second type is a commercial lease agreement. This is similar to a standard agreement but applies to businesses renting an office, industrial, or retail space. It also has a set term. There are legal consequences for breaking a lease with a fixed term. A month-to-month lease, on the other hand, can be terminated with just 30 days notice delivered by either party. The rent-to-own lease agreement is kind of like a standard lease but includes an option for the tenant to purchase the property. A roommate agreement is a type of lease you'd use if multiple individuals are renting a room in the same home. The last type of lease we'll discuss is the sublease agreement. This gets used by a tenant who's locked into a lease but wants to sublet the property for some time. Now, let's turn our attention to the disclosures a landlord is required to make to a tenant before signing a lease agreement. First, the landlord must disclose the name and contact details of the owner or manager of the property. Next, the landlord must state parking rules, including vehicle towing and parking policies. The landlord is also required to notify the tenant if parking policies change during their tenancy. Moreover, the landlord must let the tenant know that it's acceptable to terminate a lease early in situations involving family violence or military deployment or transfer. If the property was built before 1978, the landlord must inform the tenant as to whether the walls and ceilings contain lead-based paint. And finally, the landlord must let the tenant know that they are entitled to remedies if a repair isn't completed within 7 days. Let's talk about when a landlord is allowed on the premises during a tenancy. A lot of states have rules for notifying the tenant, but Texas does not. A landlord is technically allowed on the property at any time, however, it's courteous and recommended to let the tenant know. Finally, let's talk about evictions. It's against the law for a landlord to change locks or forcibly remove a tenant, no matter what the tenant has done. So what does the law say? In Texas, a landlord can evict a tenant who doesn't pay rent or who breaches a lease in some other way. This can be done by giving the tenant a notice to quit. If the tenant doesn't pay or rectify the problem within 3 days, then the landlord has grounds to file an eviction suit in a justice of the peace court. This notice to quit is different from a 30-day notice to quit, letting a tenant with a month-to-month lease agreement know that the lease is being terminated. For more information about rental agreements in Texas or any other state, as well as for resources that break down other legal matters, visit eForms.com. We've got every official form you can think of and probably forms you've never heard of too. Get yours today.